Fortunately, New Jersey's probate proceedings is not that difficult compared to many other states. The process is commenced by the individual taking the original last will and testament or any codicils that maybe also have been prepared, together with a certified copy of the death certificate, to the surrogate's court in the county in which the decedent was domiciled. The process is fairly easy at that point in time. You sit down typically with a probate clerk. They examine the will to make sure that it was properly executed, and take some information regarding the heirs, the size of the estate. And then following that, and signing off on qualification papers and application papers, the surrogate's court will issue what's called letters testamentary, indicating that the will has been duly probated, and it will state the individual that has been appointed as the executor of the estate. If there is a trust established under that last will and testament, during that same meeting with the probate clerk, the trustee will also be appointed, and letters of trusteeship will be issued to the trustee. With those papers, brokerage firms, banks, they'll know who they're dealing with and know that this person is in fact authorized to be acting on the behalf of the estate. Following that, within 60 days following the notice of probate, the court rules of the state of New Jersey require that a notice of probate be sent to each beneficiary of the estate, informing them of the right to also have a copy of the will furnished to them. Following the probating of the will, the executor will start the duties of gathering all the assets, determining what debts are out there, and then paying off those debts and maybe any taxes that may be due to either the federal government or to the state of New Jersey for any estate taxes that may be due and owing on that estate. Other than that, the executor would be responsible for reviewing the terms of the will, seeing to whom the property is going to be distributed, and making sure that the proper amounts are distributed to either individuals, sometimes to charities, other times to a trustee to be held in further trust for the benefit of the beneficiaries. So once that is done, to close the estate, many times the executor will be required to file an accounting with the court. Other times that could be done more informally by an informal accounting and a settlement agreement between the beneficiaries and the executors. If money is to be distributed to a trustee, the executor will then issue a check or issue property to the trustee, and the trustee will then be responsible for holding and managing those funds separately in a separate entity known as a trust. And then the last step the executor normally takes is to receive what's called a refunding bond and release from each of the beneficiaries, indicating that they have received a certain dollar amount that they were entitled to under the will, and that the beneficiary promises then to return their pro rata share of that inheritance to the executor in the event that down the road a debt is found, which the executor did not reserve any funds to pay for down the road. That process for the executor could take a year to 2 years, depending on the complexity of the estate, whether assets need to be sold, but in many times it's not that difficult of a process in New Jersey.